There are three broad categories of criminal offenses under the Canadian Criminal Code, and we describe them this way. There are summary conviction offenses, there are indictable criminal offenses, and there's what called dual procedure criminal offenses. And I'll give you an example and explain. A summary conviction criminal offense is an example is causing a disturbance. Pretty simple, low-level offense. It's still a crime, though. You're downtown Toronto screaming and yelling on the streets and disturbing the public for 15 minutes, and the police arrest you for causing a disturbance. You might get convicted. The penalties are limited for summary conviction offenses. These are the least serious crimes. Under Section 787 of the Criminal Code, the Crown can now ask for up to 2 years less a day in jail, even for that low level of crime, and up to a $5,000 fine. Now, there are also straight indictable offenses, which are very serious crimes. Now, murder is a straight indictable offense. That gives an accused more rights, but it gives the Crown greater rights to ask for increased penalties too. So an accused in that case can elect to have a preliminary hearing and can elect, to go to Superior Court and have a judge and jury trial, or they do have a judge and jury trial in Superior Court on first-degree murder. Now, there are also what are called dual procedure offenses. Now, murder is a straight indictable offense. There's no summary conviction murder charge, fortunately, because that's a serious crime. Now, there are also dual procedure offenses where the offense could be minor or it could be serious. Now, let's take an example, assault causing bodily harm. Now, bodily harm could be very serious or it could be trifling. I mean, a bruising could be bodily harm. So on a bruising case, assault bodily harm, the Crown's going to elect summarily. And again, it limits the penalty to 2 years less a day or a $5,000 fine. Or the guy's got a broken arm, the victim, they're going to elect by indictment, and there's a penalty of up to 10 years. So dual procedure, that crime could be more serious or less serious. Straight summary is obviously a lesser criminal code offense, and indictable is the more serious charges. Now, an important issue is under our criminal code, the police have up to 1 year to lay a summary conviction offense against a person. It's a limitation period. If it goes to 1 year and 1 day from the time it happened, they can't lay the charge. For example, that screaming match the guy had in downtown Toronto disturbing the public, 1 year and 1 day later, the police cannot lay a charge. So let's take an assault charge. That's dual procedure, simple assault. So unfortunately, 1 year and 1 day after a very simple minor pushing assault, the police could lay a charge. But the Crown would have to elect by indictment. Okay, so that's a little primer on the three categories of crime. It's really just think of summary as being less serious, generally indictable more serious, with the caveat that sometimes minor crime has to proceed by indictment if the limitation period of 1 year passes. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.